Good afternoon, everybody. Aaron Keller along with you on the Law and Crime Network for the afternoon and, of course, into the evening as we continue to cover this trial out of Southern California, the Jason King case, where a member of the U.S. Marines is facing murder charges over a drunk driving accident. Adam Sostrin is one of our regular guests here on the Law and Crime Network. He's joining me now to talk about this case. Adam, good to see you again, and thankfully we are covering a case out of your home state.
Lovely, sunny San Diego. Terrible thing happened there.
Yes, it's a horrible case, but you're the exact person to talk about with this because you have more expertise, obviously, about a case that happens in a state whose laws you're familiar with than some of these other cases that we've covered. So I want to jump in. The big question everybody's been asking is how is it that a drunk driving case, which is just a horrid case, it's a pathetic case, feel sorry for everybody involved with it. You've got 2 medical students dead. A number of others were injured in this case. People who, as you pointed out earlier, working to better themselves, better the world around them, wind up getting cut down by this defendant whose defense attorney has admitted, hey, look, he was out drinking and then he got on the road and he caused this. But how do we get to murder charges here? That's the question everybody wants to unravel. And we've been talking about this for quite a while here. And you said that it's not uncommon because of a form that defendants are oftentimes more or less forced to sign. So if they get in trouble a second time, they can be charged with murder if they have a second drunk driving situation that leads or results in death. Talk to me about this form. This sounds interesting.
Sure. Well, it's something that's been on the books for a while. It's called the Watson Advisement. Typically, every plea form for a DUI has some language in it. In addition to the fact, when you plea, it means you're going to get a conviction, and then after that, you're presumably going to have a sentence maybe that day, 5 days later, or even later than that if you waive time. But you get a conviction, you get a sentence. But while you're getting convicted, one of the things you agree to, in addition to giving up your right to trial and to testify and all those things, to accept this offer, which is a DUI and probation and all kinds of things you have to do for it, you have to agree to certain language that's on the form. And more or less, I don't have it right in front of me, but you basically agree that drinking and driving is dangerous. And when you drive a car and you're under the influence and you kill somebody, you can be charged with murder. It's called the Watson Advisement. It comes from a case, People v. Watson. The idea is if you agree to that language, the prosecutor wants that from you, the court wants that from you. So just in case, the next time you go out and you drink and drive and you kill somebody, they can use that form that you signed, that plea form. It can go before the court during your trial, and it can show knowledge that drinking and driving is inherently dangerous to human life. And they need that in order to prove up a second-degree murder charge. To get convicted of second-degree murder, or just, let's say, to meet the elements of second-degree murder, you have to commit an act that leads to somebody's death. The natural results of it, the foreseeable results of your act, are that somebody could be seriously injured or killed, and you intentionally engage in that behavior. So they know that it's foreseeable because you read that form. So they use that form to prove up these second-degree murder charges. So what would otherwise be an awful vehicular manslaughter or involuntary manslaughter case, we call it vehicular manslaughter, it becomes something else entirely. It becomes an actual murder case where you can get 15 years to life for second-degree murder. And so every time you get a DUI, you have to fill out one of these forms and agree to this language.
That's really interesting because it sounds to me an awful lot like trying to pound a legal square peg into a round hole. In other words, the law doesn't clearly say this, so then we're basically trying to get defendants to agree with the state's interpretation of it. And look, if somebody is engaging in additional drunk driving, and they wind up with a second offense after they've already gone through the ringer, through the system for a first offense, you know, we as a society don't look upon them as good people. But, you know, look, this sounds a little bit tricky to me. Do you not agree?
It is interesting. It's not like a, you know, murder is something that's you know, required to show murder. You have to show intent, premeditation. Any other murder in California, second-degree murder, you don't have to show any premeditation, but it has to be intentional. Clearly, you know, this person, as the person in this case, didn't intend to go out and kill somebody. So I can understand the complaint regarding sort of raising what would otherwise be a vehicular manslaughter case to a murder case. But California, we want punishment for people, the legislature has decided, for people that kill people from drinking and driving. And if they don't, typically, if there isn't some prior Watson advisement, all you would get would be this vehicular manslaughter charge. And what's interesting about the case that we're covering today is the fact that there was no Watson advisement. It's not a Watson murder, but they're imputing knowledge based on the fact that this Marine had taken courses with respect to alcohol. I think one of them was just 8 days prior to this incident. So they're using that to make this a second-degree murder case. Yeah,
so let's recap this. So oftentimes, if there is a drunk driving death in California, it can be charged as a second-degree murder. But if it's a second offense for someone, because after the first offense they got this so-called Watson advisement, this form, where they basically just admitted or told the court, oh yeah, if I get in trouble again and it causes someone's death, you can go ahead and charge me this way. So you know, usually, apparently, the defendants are kind of hamstrung into signing this thing if they want to plead out on their first case. But in this case, it's different because there's no form. They're trying to impute this knowledge through these courses that this guy took. So, first of all, this does happen in California. It usually happens through these forms. But in this one, there's no form. They're trying to get the knowledge a different way, and it's through the courses this guy took through the Marines.
Correct. It's very interesting. And his attorney, Richard Hutton, and I was just telling you, Hutton and Wilson, they really are excellent attorneys. And people go to them for DUIs. And were I to find myself under terrible circumstances, I might consider retaining them. I've seen Richard Hutton in trial. Anyway, so he's the attorney for the defendant in this case. And he argued to the judge, look, the problem, if you make this a second-degree murder case, what isn't second-degree murder with respect to killing somebody when you're drinking and driving? I mean, in other words, wouldn't it be easy to prove in almost any case? Did you take a course in college? Did you take a course in high school with respect to drinking and driving? Did you take any type of course when you were applying for your license? Sort of how far does this go back? And I think it's based on my reading of the reports of this trial, I think the judge sort of understood what he was talking about. And I think the court sort of agrees that you can't charge somebody with a second-degree murder every single time. I guess there's probably something unique about this case, the fact that this defendant just took this course 8 days prior. That's what I'm thinking.
That may be it, and it also may just be the egregiousness and the seriousness of the crash. We've been looking at the photos. We've got young victims who were killed. They were medical students. They were looking forward to presumably very, very promising futures. And you probably have a community that's outraged and is probably saying, hey, look, this guy should face a tougher penalty. So it seems to me that the prosecutor is trying to take the old square peg and pound it into a round hole to get a drastically higher penalty than what the legislature specifically laid out in the statute for this specific sort of offense. So even if you get a conviction here, is it possible that we're going to see an appeal that this statute was never designed to cover this kind of conduct?
Sure. You know, of course, the response from the appellate attorney from the state could simply argue that, well, all you have to show is, you know, some type of knowledge. And does it have to be a Watson advisement every single time? No, the statute, of course, doesn't say anything about requiring that there be a Watson advisement. But of course, going back to the first part of what you said, I can understand the court's perspective on this and the fact that it was a terrible tragedy. These people had you know, gone through all this schooling and you know, for their lives to be so abruptly changed or ended Truly, it was a tragedy, but the issue being that it's a little bit scary when you think that you can get charged with second-degree murder without having to sign this form, that it can be so broad. And I think I was saying before, criminal cases are different than civil cases. For civil cases, if you want to get something like punitive damages in a case, you have to show some sort of knowledge. So they'll actually go back and find out that the defendant has the other car driver had a drinking problem, that they had seen maybe a therapist for it, that they had gone to classes for it and things like that. And that's sufficient without having there to be a Watson advisement. But this is a criminal case. It has to be held, to the highest possible standards, and they're doing it based on this class that this Marine took. I wonder, in fact, if there's going to be testimony regarding what exactly was in the course. I wouldn't be surprised.
Yes, that's my understanding based on the witness list, that's probably what we're going to see here. But, this kind of bugs me because again, I keep using this euphemism, and it's old and it's tired, but it fits. It's a square peg in a round hole situation. If we want to decide as a society that we should severely punish drinking and driving, and look, I would agree that we should, okay, this sort of stuff shouldn't be happening. People shouldn't be getting this drunk. They shouldn't be getting behind the wheel. They shouldn't be driving in that kind of a state. And if something bad happens, as it did here, I think they should be severely punished. I agree with all of that. But, okay, if that's the decision we're going to make as a society, Adam, then it seems to me that we need to write it into the drunk driving laws. We don't need to keep trying to find a way to wedge second-degree murder into a drunk driving situation. My first law license is in New Hampshire, and there the state is known for being very, very strict with drunk driving. You can get convicted in New Hampshire for basically being, the operative phrase is, in actual physical control of a vehicle. That includes being asleep in the front seat in a rest area with a high blood alcohol level. If you can be in imminent actual physical control of a vehicle there and you're inebriated, they can nail you for it. And the penalties are pretty stiff. So why doesn't California just turn around and say, hey, look, you know what? We're going to throw the book at people who engage in this kind of behavior. Put it in the drunk driving statute.
Well, just 2 points. California, in fact, it does sort of have a way for you to get charged with DUI just by being in physical control of the car. I've had those cases before in the past. Ignitions in the keys are in the ignition. The person's sitting in the driver's seat. DUIs or attempted DUIs. Those things do happen here all the time. But I understand with respect to why are we merging vehicular manslaughter with second-degree murder? There's two different things, and why not amend the statute? That, of course, that'd be up for the legislature to do, but I guess I could see it being that you add another section of the vehicular manslaughter statute, the involuntary manslaughter, that if the person's drinking and driving and took a course in DUI, for instance, the prosecution can add an additional 12 years to the offense or something. I could see that happening. It doesn't exist on the books. I understand that we've been merging it. We've been doing it for a long time. I think the People v. Watson case is not that new. Find out. So,
give you a second for your research there.
I wanted to find out if the People v. Watson case came out to charge a second-degree murder for a person who had a first, and it looks like 1983.
So it's been around there for a while. So this happens. It just doesn't frequently happen on a first offense. That's what makes this unique. It's unique because it's a first offense, and it's unique because it's they're trying to impute the knowledge element from these courses, not just from signing one of these forms that a defendant would have received on a proverbial first run through the mill here.
But if I could sort of, also say that, well, maybe it makes more sense for the person to get in trouble for having taken the course where they talked about it versus a person just signing a document that day and getting his conviction with respect to imputing knowledge. If you want to look at it the other way.
You could. I mean, I don't know. So do you have to prove that the person was literally present in class that day? What if the person's out sick? It's like how,
Sure.
how far do they have to go to try to prove this if they're going to wedge it in that way? I'm curious.
It would be some kind of a morass to figure that out, and perhaps that's why they just stick with, well, we got your signature here and your initials here, and that's all we need. Makes it easier.
Yeah, so to get to second-degree murder in California, we want to talk about the elements of that just very quickly here. It's got to be willful, and it's got to be an activity that's inherently dangerous. So as sort of a big umbrella heading here, it seems pretty easy if you're involved in something that causes the death of someone. Of course, you need that. But it seems like it's a relatively easy standard to get a second-degree murder conviction in California. Is that accurate, do you think?
That's correct, and also it has to be reasonably foreseeable. So in other words, making you the, as we called it in law school, the proximate cause. You know, it's reasonably foreseeable that your conduct could result in death. That's the third prong of this, and of course, whenever it's a dangerous activity, you can assume that the person thought these things, and you can definitely assume it when the person signs this plea form, let's say for a first DUI, which we don't have here.
Yeah, that's what makes this a little bit different here. So willful conduct is a pretty easy standard to hit as well. Was this willful conduct? Do we have this in this particular case?
Well, willful is not it's not something that requires specific intent. It just shows that you sort of knowingly engaged in conduct on sort of volitionally, that you did this, you opened up the door, you walked outside the room. Those are all examples of what would be considered willful conduct. So this case, this person used his keys, got into the car, and started driving. So the willful prong's pretty easy to meet here.
Okay. Now, we're getting a couple of questions about exactly what happened here. We know he was going the wrong way on what sounds like a highway. We know he killed 2 medical students, a couple of young women, Madison Cornwell and Ann Lee Baldock. Those are the victims' names. We know that he was out drinking with some friends, and we know that one of them claims to have, at least one of them, I should say, claims to have gone to him and said, hey, look, you're drunk, you're in no position to drive. But the defendant still went and got in his vehicle. Some of the staff at the establishment where they were drinking told him that as well. So he starts drinking in a hotel room, and then they, or not a hotel room rather, but I think that they were at some sort of a hotel bar, if I'm remembering this properly, and then they went to another place called In Cahoots. It's a local establishment, and the manager was testifying into the evening yesterday. So there's a lot of warning signs that this guy knew he shouldn't drive, and one of the friends was at least testifying in a preliminary hearing that she told him, hey, look, I'll give you a ride to an apartment. Some other people apparently told him, hey, look, we've got a hotel room. You should also come to the hotel room. You shouldn't be out on the road. But he still got in the vehicle, got behind the wheel. So, yeah. I mean, is that going to play into this? Is that enough as well?
Of course. You know somebody's had way too much when 10 people in the room are all saying, hey, don't get into a car. And in fact, California passed legislation precisely because of this incident, that people that run bars are supposed to take courses and, you know, make sure that their patrons aren't drinking excessively and that they don't get behind the wheel. And everything's changed. And now we have this new designated driver law in California that if you go to a bar, the bar can actually pay for and arrange transportation for you to go home.
Yes. So pretty bad facts here, but I think that the cross-examination last evening of the bar manager was quite good, because there were a few holes that could be poked in his testimony, and we heard some of that last evening. Some of the things we heard are, you know, hey, wait a minute. Many times the manager wasn't sure if this particular defendant was actually injured or whether or not he was drunk. And he was vacillating back and forth about that on cross-examination. I mean, is it really at issue that he's drunk here? We've got a blood draw that was a little bit higher than a 0.14, and it was done a couple of hours after the crash. So why is the defense spending so much time trying to get into whether or not this guy appeared drunk?
Well, obviously, if the person appears drunk, first of all, the bar has a few things. The bar faces civil liability in this case under the, I think it's the Dram Shop Act. They're supposed to give these people water. The defense wanting to find out whether or not a bartender knew he was drunk shows whether or not it was obviously clear or into the car. Because if it wasn't, you know, maybe it wasn't willful, it appeared to everybody else. So those are things that you might want to dig into.
It seems to me that it's a lot of time spent trying to figure out whether or not the guy was drunk when you've got the blood alcohol draw, which pretty much makes the conclusion. Is it possible that where the defense was trying to go with this is to say, well, look, Mr. Bar Manager, if you weren't sure whether he was drunk or injured, is it possible that the defendant didn't realize how bad off he was? Is that where they were trying to go with that?
I think that's exactly what they were trying to do. If it's unclear what foreseeable consequences were there, but of course with all the other witness statements, it's enough to put him over the edge. And of course, but the .14, the defendant's not going to be aware that he's a .14 when he gets into the car. It's going to be the measurement that's taken. So it doesn't play into the elements. It does in the sense that it shows that he's impaired, but whether or not he was aware of what he was doing at the time, it certainly doesn't show that. It would be clear to somebody that they would appear to feel impaired, but everybody operates differently would be the argument, and perhaps he wasn't thinking there was anything wrong. And I guess, if you're Richard Hutton, those are some of the things that you want to find out about.
You were saying before that you have knowledge of the defense attorney who's handling this case. What more can you tell us about his practice?
They have a great, thriving practice. I think Richard Hutton actually defended Paris Hilton in her DUI case, if I'm not mistaken. I don't know when that was, maybe 2007, 2006, 2008, I can't remember. But I actually was at the courthouse at a time when he had a jury trial for a DUI, and he was successful for his client. And the jurors, I think they all seemed to agree that the attorney was so smooth that the defendant was able to get off in the particular case, meaning just that Richard Hutton did his job. And in fact, I've actually called that law firm on several occasions, talking to them about there's two things with DUIs. There's the courts, and you also have to deal with the California DMV. And there's all these sort of Byzantine rules at the DMV, that attach to DUIs and the consequences. And so, no, they're great attorneys. They're likable. They do well for their client. And I'm not surprised that he's retained in this case.
So let's say that this drops down to some kind of a vehicular manslaughter or something like that. If that's where this thing winds up, the penalty is nowhere near what it would be for second-degree murder. Second-degree murder in this instance is a minimum of 15 years, and I think it goes all the way up to life, doesn't it?
Right. You're eligible for parole at 15 years, but for just a regular involuntary manslaughter, it's about a 2 to 4 year prison sentence that you can get for the offense. So yeah, it's clearly different. And of course, if you're the attorney, you can't try to beat every single charge. You have to have the jury think that you have some integrity because you are representing the defendant. So I think you even have a higher standard than the prosecutor. So that's why he's saying, look, I get it. He did this. This was wrong. But was this murder? No, it's not murder. And so his job is to raise reasonable doubt there, because there's no way that, of course, that he's going to escape the, any kind of involuntary manslaughter conviction if he doesn't get convicted for the murder.
Now, that seems like a slap on the wrist penalty if this does not result in a murder conviction.
It does. It absolutely does. It would appear to be a slap on the wrist. It would be very sad indeed, based on what occurred, for that to be the only punishment.
One chain of conversation that's kicking around in one of our several chat rooms right now is whether or not the bar itself is going to face any repercussions for the amount of alcohol that was served to this defendant. It looks like they're just starting to bring the jury in now, Adam, but very quickly, do you have any sense of what could happen to the establishment?
Well, I think that the establishment can get in trouble for knowingly allowing a patron to leave the establishment in an intoxicated state. And I think that's called, I think we learned about that, I think that's called the Dramshop Act, which is as old as time. And it's a case law which makes a business which sells alcohol, who sells liquor to their patrons, who's obviously intoxicated, they become strictly liable if there's, a death or a bodily injury as a result.
Yeah, it looks like they're starting to bring the jury in here, Adam. The camera in the courtroom feed is aimed up at the ceiling. They usually come back into session after a lengthy lunch at about 4:30 Eastern.
Let me just say this briefly. It says that the dram shop laws in California are extremely limited. California's actually removed certified for businesses to serve alcohol to patrons. I wanted to say that.
Okay, it looks like we've got some action in court, so let's cut back. Again, this is the Jason King case out of San Diego, California.